My name is Tifanne Wolter, and I am an attorney here at Henningsen and Snoxville in the Family Law Department. And I was just realizing the other day that now that it's 2022, I am going on my 20th year of practice, and it's hard for me to believe that it's been 20 years now, almost, since I graduated from law school. Makes me a little humbled, I guess. But anyway, let's see. We're here to talk a little bit about some family law related topics so that you can get to know our attorneys here at Henningsen and Snoxville. And I thought what I would talk about today, since we're going through kind of a busy season, is do I really need an attorney to help me with my divorce? And of course, because I'm an attorney, my answer is always going to be yes, of course you need an attorney to help you through your divorce. So people will come back to me and they'll say, well, my spouse and I get along, we don't have any kids, we've always kept our assets separate, can't we just go on the court's website and fill out the paperwork and file a divorce on our own? And sure, I always tell people, yes, you can do that, but you don't necessarily know if you've completed the forms correctly. You don't necessarily know if there's things that you've forgotten or you've left out. And trying to fix the problem afterwards is always 10 times harder and 10 times more expensive than it would have been to just pay somebody at the front end to take a look at things and make sure that you have done it correctly and that you've thought of everything, right? So a couple examples that I can think of that happened in my practice over the years are I had a situation where the parties agreed, I'm just going to get my assets, you're just going to get your assets, we'll go and we'll fill out the paperwork and we'll turn it in and life will be great, right? And what happened was the parties filled some of the paperwork out online with their computer, and then there were some things that when they met they realized they had forgotten, so they listed those out. They put in all of their assets and all of their retirement accounts and things like that, but they didn't add values to them. And then they signed off on the paperwork, and wife said, okay, husband, you take it to the courthouse, you turn it in. And on the way to the courthouse, husband listed the values of all of his retirement accounts in the documentation, turned it into the court signed off on it, and it turned out that husband had over $75,000 worth of retirement assets that he had never told wife about. Like, she knew he had retirement, she just didn't know that he had that significant amount of retirement. So of course, she gets this decree in the mail and was like, well, what the heck? I didn't understand that he had that much in assets. And so she comes to me, and the problem is how do we prove that he added those values afterwards? How do we prove that wife didn't know that he had that much in assets? And how do we prove that she should have gotten half of that retirement account? So it was a very difficult case, and the court didn't end up coming out on client's favor because she, like I say, she didn't have any documentation that was added afterwards, or that she didn't actually know that was what she was agreeing to when she signed off on that paperwork. In addition, I think a couple of months ago, there was a case that came down from our Court of Appeals where husband and wife had filled out all of the paperwork together, and they had put in there that they were going to be equally dividing all of their assets. And it turns out that husband had a retirement account that he had not put in the documents. And wife found out about it, or maybe she knew about it, who knows. But several years later, she realized that there was this account, and I think it might have even had like $250,000 in it, that was not listed, that was not an asset that was divided as part of the documents that they filled out on their own and turned to the court. So wife then hired an attorney, went to court, the judge said, no, it's his, right? You didn't list it as an asset to be divided, so he gets to keep it. They then appealed that order to the Court of Appeals. The Court of Appeals said the same thing. It wasn't listed as an asset to be divided, and therefore, we're just going to give it to him. So again, a couple of reasons that I've seen recently where, sure, you can go in and you can fill out those paperwork and you can go and you can get the divorce on your own, but mistakes can be made, and it's better to have somebody who's trained in the area of filling out these paperworks and drafting these decrees to go over it and do that. I know that there's a lot of times where clients too believe that because an asset is listed in their name, it's their asset. We don't often realize that when we're going through the divorce process, everything that both spouses have acquired during the marriage, regardless of, whose name it's in, is a marital asset that actually needs to be listed on the document and awarded to someone. So, just because you think, well, I have this retirement account and it's in my name, I don't need to list it, or I own the house and it's titled in my name only, so I don't need to list it. That's not true. Everything that you own needs to be listed and it needs to be awarded to someone. So, like I said, it's always best to have somebody who's trained go over this information, take a look at it, give you an opinion, give you an evaluation. Here at Henningsen and Snoxville, all the family law attorneys here are more than willing to do that for you. So give us a call. We're here to help you for any of your legal needs. Thanks.